Welcome to the ABA Division for Public Education's On the Docket Supreme Court program, hosted in partnership with the Woodrow Wilson International Center for Scholars. I'm Gary Slayman, the chairman of the ABA Preview Advisory Board. Preview is a flagship publication of the ABA Division for Public Education, and for decades has been the only resource to provide detailed analysis of each case before the Supreme Court prior to oral argument. Each preview issue highlights the main issues before the court in a way that non-lawyers and lawyers alike can understand. The Preview Board is delighted to welcome you to On the Docket, the Division for Public Education's annual Supreme Court panel. We're excited to be hosting this program once again in partnership with the Woodrow Wilson Center. Today we've assembled a great panel to help us better understand the significance of the October 2014 term and give us an inkling of how some of the headline cases for the upcoming term will play out. Our moderator will introduce each of our panelists, and I would like to say something about our moderator myself. John Maluski is a great friend of this program for many years, as a veteran broadcast journalist and communications professional with extensive experience as a moderator, interviewer, anchor, producer, and reporter. He is currently the director of digital programming for the Woodrow Wilson Center for Scholars. John, thank you for your generous support for our programs and for having us here at the Woodrow Wilson Center.
Pleasure. Thank you, Gary. Thanks to everyone for joining us as well. Let me also welcome you to the Woodrow Wilson International Center for Scholars. I'm just curious, how many of you have been here before? Oh, great, a lot of returnees. And those of you who are coming for the first time, special welcome and hope you'll come back. This is the nation's official and living memorial to its 28th president, Woodrow Wilson, who had something very unique about him that no other president can claim. And no, not that he was a lawyer. A lot of presidents are lawyers, right? Do you know, anyone know what it is?
PhD.
Yes, he was a PhD. Yes, ma'am. He was the only, imagine that, the only U.S. president to be a PhD. So welcome to the Wilson Center for the annual On the Docket program. It's a great pleasure always to work with the ABA Division for Public Education, who, as you will see in a moment, always do such a terrific job in bringing an A-list guest list to the event. You'll know a lot more about the Supreme Court in the coming term when you leave this room than you do currently. I can guarantee that. Very few other things I can guarantee. So you've all picked up one of these when you came in. Previews, it's a terrific resource. It has detailed bios of our panel, but I'm going to give you the short version, particularly for those of us, those people not in the room, joining us via the webcast and via C-SPAN too, who are unable to pick up a copy of this book in the room, but they can find it online. So let me introduce you from your left to right. Joining us is Neil Katyal. That's actually your right to left. We reversed ordered here. Neil Katyal is a partner at Hogan Lovells and has argued 21 cases before the Supreme Court, 21 and counting because more this year on the way. Previously, he served as acting Solicitor General of the United States and also served as a law professor for 15 years at Georgetown University Law Center, and that was all before the age of 21. Is that correct, Neil?
18.
I think 18. Also with us, Leslie Kendrick. Leslie is a professor of law at the University of Virginia School of Law, where her primary research focus is freedom of expression. She'll be talking about some First Amendment cases tonight. Prior to joining UVA, she clerked for U.S. Supreme Court Justice David Souter. Also joining us, Janae Wilson. Janae is the Associate Director Counsel for the NAACP Legal Defense and Education Fund. Previously, she was Associate Dean for Faculty Scholarship and Associate Director of the Ronald H. Brown Center for Civil Rights and Economic Development at St. John's University School of Law. And finally, Stephen Wormiel joins us. Stephen is a fellow in law and government with the American University Washington College of Law. He is co-author of a biography of Justice Brennan, a columnist for SCOTUS blog, and previously served as Supreme Court correspondent for the Wall Street Journal. Please welcome our panel to today's discussion. Let me tell you a bit about the format, those of you who have been here before. We've asked each of our panelists to provide briefings, something they're very good at, on a variety of upcoming cases, in some cases by category and others a little more free form. So when each panelist does that presentation, then we'll engage him or her in some discussion of the cases. Then eventually we'll turn it to you and we'll ask for your questions and comments. But first let me begin with a general question about the state of the court. Is the court currently either more political than it's ever been or less political than it's ever been, or somewhere around the average? Let's begin in order of introduction. Neil?
I have some pretty strong views on this and wrote about them in an op-ed for the New York Times in June. If you look at the last term of the Roberts Court, you see something very striking. It's never happened, or I shouldn't say never, but in most of our lifetimes it hasn't happened, that the court agreed unanimously in roughly 2/3 of the cases it heard. Indeed, there were only 25 decisions that it decided last year that were not unanimous. So 2/3, you'd have to go back to 1940 to find another Supreme Court term like that. And so when you read the newspapers and the Supreme Court bitterly divided and partisan, there's certainly some of that. Certainly elections have consequences. But I do think one thing we're seeing with the Roberts Court is a real striking emphasis on unanimity. And I think it's fitting that we're talking about it here at the Wilson Center, which is, of course, devoted to kind of nonpartisan, true engagement with ideas. I think the court is looking over at Congress and seeing something a little bit dysfunctional, and folks who can't get anything done and can't agree on anything, and they're fighting about the small things. And I think the Roberts Court's saying, look, we're certainly going to have our disagreements on the big hot-button cases, but can we find common ground? And they did in 2/3 of the cases, including massive cases that affect you and me every day, like cell phone privacy.
So in a way, the court is looking to Congress for inspiration of a sort. Leslie?
Well, I think these comparisons are really hard to do. And to Neil's point about the amount of unanimity, I think it doesn't take that many hot-button cases where people see a really divided court for that to be the impression that people take away. I remember when I was clerking, there was a case, one of the parties involved in it was called John R. Sand and Gravel. And I remember thinking a surprising amount of the Supreme Court docket is basically sand and gravel. It's not very interesting to most people, not very hot button cases that really need an answer, and they provide one, and they can do that extremely well. But it doesn't take that many cases that are more fireworks for that to be what people pay attention to. And I think it's in that context where there are a few cases that are very hot button, it's very easy to say this is more political than the court's been in the past when we don't have a sense of just how much fireworks was happening in the past because those are settled questions for us now. It's hard to make the comparison.
Janae, what do you think?
I would agree. I think it's very difficult to contextualize it, and I apologize in advance for my voice. I think we also have to put in context the number of cases that the Supreme Court has taken in recent years, and it's been dipping significantly every time. Every time that the court opens for a new term, we see a shrinking docket, and so therefore the number of unanimous decisions that Chief Justice Roberts has been able to coalesce among the justices, is impressive. But there are a much smaller number of cases that we're working with in this docket.
Do less cases equal more agreement, historically speaking?
Well, it's also the kind of cases that the court is taking. And I absolutely agree. Some of them are the mundane, run-of-the-mill sort of circuit splits that need some resolution, but are not creating law that is jaw-dropping. And others are the big jaw-dropping cases. And I think the cell phone case is a good one to point to, where you see unanimity. And I do wonder, though, what are we losing with that unanimity? And so to say whether it's more or less political, we have to think about what's being cut out of the edges to create a more consensus opinion, and that in and of itself could be political.
It's like a family having a rule, never discuss religion and politics at the dinner table,
right.
so we can all get along. Yeah. Steve?
I would make 2 points. I think there's a lot of unanimity, but I think some of the unanimity is elusive. The cell phone case, for example, I think the court did a very good job of narrowing the issue to something that all 9 of them could agree on. But it's not the last cell phone case we're going to see, and the next time it comes back it won't be unanimous because they masked some of the disagreements, and I think they did that in some other cases too. To their credit for trying to find common ground, but don't make a mistake in thinking that it's necessarily that all issues are being resolved in that way. The other thing I would say is I agree with Neil that I think the court is very cognizant of Congress being dysfunctional. But interestingly, one of the offshoots of Congress being dysfunctional is when the court strikes down federal statutes, we presume that Congress can correct the mistakes in those statutes if they want to. And a dysfunctional Congress can't do that.
You're not painting a picture of a highly partisan undertaking. There's a lot of nuance and shades of gray, but if you hear some critics of the court, particularly around things like Citizens United or McCutcheon, you get a very different picture.
Absolutely. I mean, I think that, you know, there are certain hot button cases. Citizens United's a good example. Gun rights is another example. You know, and perhaps some of the cases that may come to the court this term, same-sex marriage and abortion, you know, may be other ones in which you are going to have that amount of disagreement. But having said that, striking agreement on things like cell phone privacy, which is a sweeping holding. This is not narrow. This is a holding that affects you and me. It's as broad as I think they could have possibly done, saying that what the government was doing was akin to the general warrants of the founding. It is, you know, one of the most significant rulings of the Supreme Court in our lifetimes. And that's true about other things as well that have been fully unanimous, things like patenting the human genome and so on, and even things that have a political valence, like the recess appointments that President Obama did, 9-0 decision saying President Obama was wrong. So certainly there are political decisions that, you know, or things that have political consequences that the court's engaged in. But I do think this court has done something really interesting in trying to find common ground.
Any other thoughts on this before we move on to another topic? What about, let's look back at the last term once before we turn our attention forward to the coming term. And is there anything that you would list as the most surprising thing about this court's performance during the last term? There's a predictability on these hot button issues that often have broken 5-4. Neil describes a specific strategy to have unanimous votes on now a record-setting amount of cases in 70 years, at least in the last 70 years. So is there anything that has surprised you, or are we talking about a highly predictable court?
Well, I think, I don't want to speak for Neil. I think the cell phone decision was probably a surprise, especially the unanimity of it. And the recess appointments unanimity was also surprising. We know that Chief Justice Roberts says he wants to try to find as much common ground on which all 9 can agree, but that doesn't mean they're always going to be able to find it. So sometimes when they do, it does kind of catch you off guard.
Janae, what surprised you, if anything?
Well, I mean, I would tend to agree that the unanimity on those decisions was surprising, and that Chief Justice Roberts seems to be getting better and better at creating that coalition, or either the members of the court are getting to know each other in a different way. The newest members seem to be, Justices Kagan and Sotomayor seem to be really jibing with the group, and there does seem to be a greater cohesion. So I can't say there was any surprises, and maybe this is part of my cynicism about there being some politics on the court. I mean, you know, McCutcheon in these cases are, you know, I thought were rather predictable. I think there are certain areas where you do find more predictability, and so I wasn't terribly surprised. I do think those are 2 outliers, though, the unanimous decisions in the cell phone case and recess appointments.
Leslie, what about you? Court watchers love a surprise.
I try not to have any expectations about the Supreme Court. They're going to do what they're going to do. And often you can predict where the battle lines are going to be drawn, but how exactly they're going to come down, trying to gauge that can be kind of a fool's errand. There were some cases that I think were big cases. Hobby Lobby is a big case. It could have gone one way or the other based on what a couple justices thought about privately held corporations. And is the result surprising? No, but it's momentous, and I think that's probably more important.
Neil.
For me, the most surprising thing about the court is not actually something that happened at the court, but the lawyers who are arguing before the court. It's not surprising that over the last 10 to 15 years, we've seen a kind of emergence of a Supreme Court bar. 71% of arguments done last term were done by people who had already done 5 or more arguments. But here's the striking thing, and it's a sad fact. Last year, 15% of the people who argued at the Supreme Court were women. 15% in the year 2014. That, to me, is a strikingly dismal figure. And I would have thought by this point in time we would see different numbers. And it's something that I think we all need to think about. And certainly those of us in the appellate world need to think about it in our hiring and our mentoring.
Okay, thanks. Now we're going to turn our attention to the coming term, and this is where we'll get into some of the briefings that we previewed earlier. And this would be high-priced briefings if these were billable hours. These are some top-notch people up here. So, Janae, we're going to begin with you, and the clock will be running. Not really, but we have about 10 minutes for this segment. But Janae is going to talk to us about voting rights cases and give us a preview of some things that are upcoming.
Yeah, well, I'm glad you said voting rights cases plural. I'm talking about a consolidated case that consolidates two cases. One is Alabama Democratic Conference versus Alabama, and the Alabama Black Legislative Caucus versus Alabama. Those two cases were consolidated, and this will be the first time that the court has dealt with a Voting Rights Act case since Shelby County versus Holder, which was the term before last, where the court dealt what I would say is a devastating blow to the Voting Rights Act of 1965. So this case is momentous for a number of different reasons, and so far, I'm looking at the petitions that the court has granted cert on, this is going to be the election law case of the term unless one of the voting ID cases makes its way to the Supreme Court, and certainly Wisconsin is vying for that honor. So we'll see what happens there. Otherwise, this will be, I think, the election law case of this term. And as you could hear from the names of the parties, there are partisan dimensions to this case, and there's also the main issue on the table, which is the racial concern. So the Alabama Democratic Conference is, in fact, a African American political action committee on the one hand. The other case, the Alabama Black Legislative Caucus, consists of African American legislators, representatives in the state of Alabama, and both parties are suing based on a Republican-led state redistricting map that came out of the 2010 census. So every 10 years, as you probably know, our states go through this phenomenal process called redistricting, where they redraw the legislative districts for state legislatures, for local commissions, and even congressional redistricting. This is challenging the state legislative map. And as I said, this is a Republican-led legislature, and the concern in this case is that the way in which they configured the districts, particularly how they included minorities in the districts, violated the Equal Protection Clause, no matter what level of scrutiny you apply to it, but especially if you apply strict scrutiny, which you would whenever there's an allegation that race played a predominant role in the redistricting. So in a nutshell, in 2000, so 10 years before the 2010 census, in 2000, this plan was drawn up creating majority-minority districts. It was litigated, it was preserved under the Voting Rights Act, and a certain number of majority black districts were created. When the legislature attempted to update that plan following the 2010 census, it continued to keep the same percentages of black persons in these majority-minority districts as they had in 2000. Now, on its face, that doesn't sound like a preposterous idea or anything that's problematic. But if you know about the standards by which we judge the legality of majority-minority districts, you'll realize that just rubber stamping or creating just a cookie-cutter image of the previous plan doesn't necessarily yield a plan that is constitutional or one that's consistent with the Voting Rights Act. So the Voting Rights Act requires, and I'm talking about Section 5 in particular, it requires that any voting change, including a legislative map, must not put minority voters in a worse position. It must not have the intent to do that, and it can't have the effect of doing that. And we call that process or that measure of determining whether minorities are put in a worse position, we call that retrogression. The plan cannot retrogress minority voting rights. So in this particular case, by including the same percentages of black population in the newer districts, the legislature did not take account of the fact that minority voting rights had actually evolved in 10 years, and that the same 77% black district that may have existed in 2000 didn't need to exist with such high concentrations of black voters in 2010. And that's really the crux of the concern there. There are a few interesting points about this case. First, as I mentioned, this is going to be the first time that the court opines on the Voting Rights Act since Shelby County versus Holder. In that case, the court did not strike down Section 5 of the Act, which I just explained, but instead struck down Section 4 of the Voting Rights Act, which created a trigger for which jurisdictions would be covered by Section 5. So basically, it was the formula for deciding which jurisdictions would be subject to this retrogression standard. In striking down Section 4 of the Act, the court left Section 5 intact, but we don't know whether, if we're able, in fact, to create a new Section 5 or Section 4 coverage formula, what the court would do with it, how well it would protect it. And I think everyone's going to be looking at this case to read the tea leaves on that important question. This is also the first time that the court will be dealing with a race-based gerrymander since Lulac versus Perry, which was the Texas mid-decade redistricting case, and Hunt versus Cromartie. It's been quite some time since the court has really dug into these thorny issues or gotten into the political thicket, to use some of the jargon, on the issues of racial gerrymandering. The second reason that this case is particularly important is because we are going to understand where the court places the value of compliance with Section 5. The Republican-led legislature, as I mentioned, created these majority-minority districts and said, Section 5 made me do it. The only reason we packed black voters into these districts at such high rates is because, and the rates are roughly 65 to 77% in certain districts. The only reason why we did this is because we had to comply with Section 5 of the Voting Rights Act. And what certainly the Legal Defense Fund is saying, and we said in the amicus brief that we filed, Section 5 requires a much more nuanced analysis. It requires a district-by-district analysis of minority voting power, of determining how much traditional redistricting criteria played into the legislative redistricting process, how much did race play a predominant factor. All of those particular questions need to be dealt with on a district-by-district basis. So we're really looking at the contours of the anti-retrogression standard, and effectively what we're saying is that majority-minority districts can come in all shapes and sizes. It depends on the voters in that community, the communities of interest, general standards like contiguity, traditional redistricting criteria. All of that must play a part in determining what is a constitutionally viable majority-minority district, and one that would be protected under the Act. Another interesting tidbit about this case is that the majority-minority districts that were created in the 2000 plan that I mentioned were challenged by Republicans in 2000 when those districts came to pass. And now, again, fast forward 10 to 12 years later, and those same districts are being protected by the Republican legislature and claimed as part of their effort to comply with Section 5. The NAACP Legal Defense Fund, where I work, we are a nonpartisan group. We are focused only on the ability of minority voters to elect candidates of choice, and we submit that certainly by having a high concentration of black voters in these districts, minority voters are in fact losing their ability to elect candidates of choice in the way that they could have years ago. I don't know how I'm doing on time.
We're a little tight, but go ahead,
Okay,
please.
so let me just cut to what I think would be the most problematic decision the court can make. Well, one, the court has a few different options. It could simply remand and say, yes, the lower court, the 3-judge panel that dealt with this case in Alabama, could now revisit this issue and apply the appropriate constitutional standards. It doesn't need to actually decide this issue on its face. There's a standing issue that was raised as well. I doubt that the court will actually decide this on standing grounds, but that's also an avenue. What the court should not do is create a bright line rule as to what is the appropriate percentage for any majority-minority district. This is really a fact-intensive inquiry that requires a great deal of subtle analysis, and that is what we think the court should order and remand to the district court or deal with the constitutionality of these districts outright and not create any racial quota.
your comment about the Republicans' feelings about this then and now. I think it's, at least politically, it seems like the problem with gerrymandering isn't gerrymandering, it's who's doing the gerrymandering where it becomes contentious. About 2 minutes left for this segment, so I want to give your colleagues a chance to either make a quick comment or ask you a quick question about this, if anyone has anything they'd like to add to this segment before we move on. We're good? Thorough. That was terrific. Thank you. That was a terrific briefing. And when we come to your questions, anything you'd like to pick up on that we're going to move through fairly quickly here, please, we'll invite you to do that, or any cases that we don't flag for you, if there's something else you'd like to discuss. Next up, we've asked Neil Katyal to talk to us about same-sex marriages, something that is bound to be another contentious issue in this court, and the court seems eager to weigh in.
So I do think that this set of issues is basically the greatest civil rights issue of our time. And the court has pending before it 7 different petitions raising these questions about the constitutionality of same-sex marriage restrictions. The cases, there's 3 of them from Virginia, there's 1 from Utah, there's 1 from Oklahoma, 1 from Wisconsin, and 1 from Indiana. The court is going to consider them and whether to hear any of these cases at all on September 29th at their first conference. The justices have a nice long summer break, kind of like folks, school children. They get a long break. They're actually working quite hard during that break, but they don't actually announce any new cases that they will hear. So September 29th is the first day when they'll take up this really enormously interesting set of questions. The first case that was filed by the state of Utah at the U.S. Supreme Court, and just by word of disclosure, I'm one of the lawyers along with an amazing team of folks across the country on the Utah case. So I'm going to stick to really the public filings in this case and tell you what it's about. Basically, Utah has Amendment 3 to its constitution, which does a few things. It restricts marriage to only that between a man and a woman. And it also says if you had a same-sex marriage in some other state, and then you move to Utah, they won't recognize that. And indeed, it bans it bans all benefits and things like that for folks who have either same-sex marriages or who have civil unions. They say that's also, we're not going to give any such benefits. So the plaintiffs, the 3 different couples, challenge that as a violation of the Equal Protection Clause of the 14th Amendment and the Due Process Clause, saying essentially this is unconstitutional, it's a denial of equality. And they won in the district court. And indeed, I think there have been 31 or so cases across the country in the last 2 years, and the challengers have won 30 of those 31. Those numbers might be slightly wrong, but it's the restrictions have only been upheld once by one district court a couple weeks ago in Louisiana, and about 30 different courts have said, no, that violates principles of equality. Now, when a law gets struck down, any law, that's a big deal for a court. Chief Justice Marshall, our greatest Chief Justice, said that is the most solemn duty of the Supreme Court, to strike down a law as unconstitutional. Because what it means is, even if the American public really wants that law, they can't have it. It's off the table. Even if it's 99.99% the people in Virginia or Utah or whatever that want these same-sex restrictions, it's off the table. So it is something that is done really, rarely, and it should be done rarely because it's an awesome power given to an unelected federal court. The plaintiffs here were able to convince the district court judge that it was unconstitutional, the Utah restrictions. It then went up to the 10th Circuit Court of Appeals, which also found it unconstitutional. And now the state of Utah, represented by its attorney general and governor, have asked the U.S. Supreme Court to come in and say, we have a right to pass the laws we want. It's our political process. Marriage is traditionally a state responsibility. It should not be up to unelected federal courts to decide who should get married and how. And they have some fairly strong arguments. They point out, for example, that the Equal Protection Clause was passed in 1868, and nobody in 1868 would have thought that it would be something that would prohibit states from banning gay marriage. Of course, the challengers say, well, that's not the right way to look at it, because those folks in 1868 also didn't believe in desegregated schools. They didn't believe in bans. They didn't believe in striking down interracial marriage. But of course, the Supreme Court unanimously did that in 1967. So the Equal Protection Clause has some evolving focus. The challengers also say, well, what's the reason for the law? Sure, states, you have prerogatives in general to regulate marriage as you see fit, but you got to articulate some reason for doing so. And in the states' reasons they find lacking, and this is one in which the states in general have had some difficulty coming up with reasons. Some of the old reasons, like procreation and stuff, have been pretty discredited by the social science literature. And so that's one of the interesting facets about these cases. Nonetheless, when the 10th Circuit ruled and struck down the Utah ban, they put their decision on hold, on ice, and said, Supreme Court, we're going to wait for you. And so that's where the law stands in Utah right now. We, as the challengers, actually did something rather unusual. As I say, the governor came in and said, we want Supreme Court to hear this case. And even though we had won the case in the Court of Appeals, we told the Supreme Court the same thing. We said, Supreme Court, we won, and we're confident we can win again before you. Give us a hearing, grant this case, and let us have our shot in court and win a nationwide rule. Because right now it's an intolerable situation. If folks are in Utah, they can't have their marriages recognized, even if they lived in another state and had to move to Utah for work or something like that. And so you had a patchwork regime, state to state, and nobody has certainty. And so the idea behind acquiescing in the certiorari petition, in the documents that the Utah government had filed, is to say, let's just resolve this thing once and for all. Second case comes from Oklahoma. That's a case also coming from the 10th Circuit. Interestingly here, however, the issue is only one thing instead of two. It's only whether or not Oklahoma can prohibit same-sex marriage. It doesn't have the recognition issue, the issue of someone being married, say, in California and moving to Oklahoma before it. For that reason, the challengers have suggested their case is even better than the Utah case because it's a little cleaner, it's only one issue instead of two, and they're represented by the gentleman who won that cell phone case that I was mentioning before, Jeffrey Fisher of Stanford Law School, an enormously talented advocate. The third, fourth, and fifth cases are the trio of Virginia cases. Now, these are all cases brought by the clerks in the state of Virginia that said, look, Virginia law restricts marriage to that between a man and a woman, and we don't want to give these licenses to same-sex couples. The Virginia Attorney General, because of a election switch, has refused to actually defend Virginia's law, saying it's unconstitutional. And so it's the clerks that are defending the law, and they are before the court also saying, take our cases. The Fourth Circuit Court of Appeals, which is Virginia, Maryland, North and South Carolina, and West Virginia, they should, that Fourth Circuit decision struck down the Virginia law. They're saying the Fourth Circuit decision is wrong, and the court should hear that set of cases. There you also have two remarkable lawyers. First, Ted Olson, who was President Bush's Solicitor General and who over the past several years has taken up this cause and said marriage equality is his battle and the battle of the country. You also have Paul Smith, who is a lawyer in private practice who argued the Lawrence versus Texas case a few years ago, which struck down bans on sodomy, bans on sodomy and as unconstitutional. Again, enormously talented legal team there. And then finally, you have two cases from Indiana and Wisconsin. These are cases very similar to those before, in which you have both marriage restrictions as well as the recognition question of people moving into state and whether those are recognized. The interesting thing about the Wisconsin and Indiana cases is that the opinion author for the Court of Appeals to strike down these prohibitions in Wisconsin and Indiana was a guy named Judge Richard Posner, appointed by President Reagan, considered a quite conservative jurist, a libertarian but conservative jurist. He just made mincemeat of the arguments that the state was putting forth, both in the oral argument and then in his written opinion. It's a very powerful, very short opinion, and one suspects will give some ammunition to the challengers of these bans. See, so I'm not biased at all on any of this. So we should know pretty soon what the court's going to do. The court has, Justice Ginsburg made some public statements last week saying that suggesting maybe that the court might want to wait for another court of appeals, the Sixth Circuit, which has a case from Michigan before the U.S. Supreme Court gets involved. They don't have to take anything. One of the greatest powers of the Supreme Court is the power not to decide. So you come in, and you heard before a point about how the court has a diminishing docket. Last year they decided 67 cases. 20 years ago they decided 150 cases. They get 10,000 cases a year. So it's really hard to get your case heard by the Supreme Court. And they're always looking for reasons not to hear it. So they might say, look, let's wait a little longer. But there's a pretty good argument that at this point in time the patchwork is such that people are living in an intolerable state of legal limbo. And so I think that's why you have this remarkable confluent agreement by the two warring camps, all the states and the governors and so on who are against same-sex marriage, and all of the folks who are in the marriage equality movement who are bringing these cases saying, okay, here's one point of unanimity, here's one point, Supreme Court, hear the case.
Neil, about 31 states or so that still have bans. Is that right?
I don't think it's that high. I think it's less than that.
Less than that. What are the chances that a ruling is made in any of these cases that wipes that away, that ends any discussion, that decides this definitively?
Yeah, so I think if the Supreme Court gets involved in the case and grants the case, they're going to grant any of these 7. They're taking it to resolve the issue, and so the issue is 100% that the issue, if the case is granted, if one of these cases is granted, that it will be resolved. I don't think that there's any wiggle room left. The court 2 years ago granted a case from California which did present this issue, but there was some wiggle room there. They exercised their wiggle room, and so we didn't get a decision. But I think at this point in time, the moment they take one of these, it's game over for one side or the other.
Any quick thoughts or questions before we Steve?
I mean, the day that the Supreme Court decided Windsor, the Defense of Marriage Act case, won, perhaps now with hindsight naively, might have read the Windsor opinion and said, this is really just about the federal government having to respect the choices of the states. But now you have judge after judge after judge saying, Windsor made me do it, and striking down the state laws. Isn't that sort of surprising?
It's a unprecedented number of state laws that have been struck down in the last 2 years. I can't think of anything in our lifetimes, perhaps ever in the history of this country, in which you've had state law after state law after state law struck down so quickly. And you're absolutely right. It's one thing if it's Brown versus Board of Education and the Supreme Court says these state laws are all unconstitutional in clear language, but Windsor didn't quite do that. You had to interpret Windsor, and you're absolutely right. Judges of all political parties from across the country are interpreting it in one way, which is to strike it down with one exception in Louisiana.
Thanks, Neil, for another terrific briefing. And Leslie Kendrick is up next. And Leslie's going to be talking to us about First Amendment cases. Leslie.
Thank you, John. I want to thank everyone at the ABA and the Wilson Center here for putting on this event, and all of you all for coming. Thank you very much for being here. So I'm going to talk a little bit about the First Amendment. And I think the takeaway so far for what the term looks like is that the Supreme Court is continuing its First Amendment fatal attraction. We've heard about their diminishing docket. And actually, I think on the First Amendment side, the Supreme Court sometimes grants cases where it's not very clear why they're taking it. They're not, apparently given the outcome, they're not taking it in order to overturn a judgment from a lower court. There's no clear split. Sometimes all of the lower courts have been agreed in the proposition that the Supreme Court ultimately endorses. It seems as though the Roberts Court has never met a First Amendment case it didn't like. And really, it's rarely met a First Amendment plaintiff it didn't like. A couple notable exceptions are law professors and child pornographers, which I don't know what that says about their opinion about law professors. But this term, they've actually taken a couple cases where a clear answer is needed. They're doing some hard work here, I think, cleaning out some cluttered closets of the First Amendment, places where lower courts are in disagreement and everyone's a little bit at sea. So the first of these is a case called Alonis versus United States. This is a case involving the so-called true threats doctrine. So, little primer on First Amendment law. There's a lot of law that's there's a lot of speech that's protected by the First Amendment. There's a lot of speech that's not protected by the First Amendment. And this is a question of when is threatening language protected and when is it unprotected? And here the question is, in order to be unprotected, in order for the speech not to be protected by the First Amendment, does the speaker have to have intended to threaten someone? Or is it enough if a reasonable person would think that this was threatening language? So do you have a subjective intent standard where you ask about the state of mind of the speaker, or do you ask about what an objective listener would take away? And just note, this is not about whether you intend to carry out the threat or not. Everyone's agreed that that's not necessary. Just, do you have to have intended to make someone feel threatened? So this case involves a man, Mr. Alonis, and I should say that the University of Virginia, where I work, their Supreme Court litigation clinic is representing Mr. Alonis in this litigation. I am not involved in that representation, so I'm not here on behalf of Mr. Alonis today. He was convicted under a federal threat statute for some very choice language on Facebook about his ex-wife and some other assorted individuals. I will not quote that language for you here. I think in the colloquial sense, many of us would say it was possibly threatening, or at least we would say it's fairly disturbing. And the question is whether legally it counts as a threat. So he was convicted under this standard that says all we need to know is whether an objective person would find this to be threatening language. So he sought review by the Supreme Court to settle a disagreement among the circuits about which of these standards is necessary. And I've got to say, if you know anything about this area of law, you might have thought this question seems familiar. You might have thought that the Supreme Court actually has decided this question before in a 2003 case called Virginia versus Black, in which it dealt with the true threat standard and said things like, threats are those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence, or where it said that the statements must be made with the intent of placing the victim in fear of bodily harm or death, where it talked about intent for many pages. So you might have taken away the impression that this was a subjective intent test, but it's not clear that that's actually what they were focused on in that case. That case involved a state statute that required intent as a matter of criminal law, not as a matter of First Amendment protection. Maybe that's what they were talking about. If they did mean to make intent a requirement, a constitutional requirement, rather than something that the statute just happened to include, they didn't really tell us why intent would be a requirement. And you might ask from a First Amendment standpoint, why do we need subjective intent on the part of the speaker? So you might think, well, otherwise it's going to chill speech that we want to protect. You go around, you say something you don't mean for it to be threatening, someone takes it as a threat. Maybe that chills your speech because next time you're not going to be as likely to speak out. But you might wonder whether intent is really a standard that's necessary to avoid chilling effect problems. Maybe knowledge is enough, maybe recklessness is enough, maybe even just negligence. You should have known that people will think that this was threatening. So it's not clear that you need it from a chilling effect perspective, and if it's from some other perspective, the court hasn't really made clear why or what that is. So, arguably, they've decided this question before, but arguably, too, they weren't totally focused on it when they decided it, and hey, they're the Supreme Court. If they want to decide it twice, they can certainly do that. The other case is Reed versus Town of Gilbert. So this involves a town in Arizona that has a signage law. Lots of towns, you may be familiar with your own town's sign laws about permanent signs, temporary signs, what kinds of signs can be up and where they can be up and how long they can be up and this sort of thing. It's all the sort of beauty of local government. And the town of Gilbert has a law that treats different temporary signs, like campaign signs, campaign posters, different kinds of temporary signs differently. So it has one set of rules for political signs, one set of rules for ideological signs, and then some other rules for other, essentially. And there's a church here, the Good News Community Church, has signs that they qualify as directional under the town of Gilbert's sign law. That is, they show people where to go to come to the services, pull in here to go to the service. And those signs are treated differently from the political signs and from the ideological signs. They can be different, they have to be different sizes, they can only be out for a certain amount of time. And this implicates an area of First Amendment law that's called content discrimination. So the Supreme Court has said, famously, above all else, the First Amendment means that the government has no power to restrict expression because of its message, its ideas, its subject matter, or content. And the question is that what's going on with this sort of sign law? So in previous cases, any type of classification based on subject matter, anything that restricts speech based on subject matter, like different treatment for political things or ideological things or other things, the Supreme Court has frowned upon. And by frowned upon, I mean ridiculed and invalidated. And when it comes to signage laws, though, there's this issue because it seems like probably towns aren't trying to discriminate against certain types of messages. Probably what they want is to be able to regulate the aesthetic quality of their environment while also giving room for campaign posters and other things they think are important, and which the Supreme Court, frankly, has said is important. So the question here is what matters the fact that on its face this law treats different things differently based on their content, or is what matters kind of the motive behind that and the risk that there's actually some sort of discriminatory motive involved? So that is a very messy Supreme Court closet, which they might be trying to clean out. We'll see.
You were very polite in not quoting directly any of the Facebook posts from Mr. Alonis.
Right.
But are any of you familiar with them? Have you seen them? Well, the point, what you know then is the language is not ambiguous or unclear. In a certain context, they could clearly be perceived to be threats. And what makes this more complicated, he's claiming to be an artist. Right, he's claiming these are rap lyrics.
Right. So he claims that these are rap lyrics, which I would think of them more as kind of free verse, maybe. But whatever artistic medium he claims to be a part of, I respect that. And so there is this kind of question floating around where one way in which this type of problem could arise is when people are involved in artistic expression, where they don't intend to convey a serious threat. What they're doing is something that's creative. So this is a particular application of this larger question of what type of intent is necessary in order for the speech to be unprotected. And although the statements themselves are pretty disturbing, the fact that it does remind the court, well, any rule you make is going to implicate artistic media. That's an important aspect of the case.
Mm-hmm. Any, Janae, please.
Well, yeah, I just want to add it also has implications in terms of an evidentiary standard when we're dealing with criminal defense cases. And this has come up already in a number of cases, and most jurisdictions have actually held that it is admissible to bring into the record violent rap lyrics, artistic expression that seems threatening. And so this is not deciding that issue, but I think it has broader ramifications. If this is in fact protected speech, then there is, I think, a stronger argument to say that that information is not or should not be admissible in a criminal defense trial. However, if it isn't, then I could actually see it going the other way in a lot of more jurisdictions.
Yeah, that's a very, very interesting issue, and this is by far the closest that the Supreme Court has ever gotten to that evidentiary question.
I mean, I also have the sense in these cases the court seems to be playing a can you top this game. I mean, the funeral protest case, Snyder versus Phelps, would have been a law professor's worst nightmare for a hypothetical, right? That you don't want the Supreme Court to be deciding free speech law on the horrible facts of this case. And now this one, I mean, what's next?
I shudder to think.
Yeah.
Well, next up, indelicately in my notes, and thank you for a terrific briefing, Leslie. Welcome to the club. You're our newest panelist here in the On the Docket series. I have listed here, Steve, other cases, because we decided that we couldn't put these into a neat, tidy category, but there were some other cases worth highlighting, and Steve graciously volunteered to be the go-to guy for the grab bag. Steve, you're up.
Thank you, John. The first one I want to talk about, Neil talked about how same-sex marriage is the civil rights issue of this era or this generation. Sadly, one of the cases I want to talk about is the civil rights era of about 40 years ago. It's a case involving pregnancy discrimination. In 1976, the Supreme Court ruled that discrimination in the workplace against pregnant women was not sex discrimination and therefore was not covered by Title VII of the 1964 Civil Rights Act. Congress amended Title VII in 1978, passing something called the Pregnancy Discrimination Act to try to change that and basically say that discrimination involving pregnancy should be seen as gender discrimination under Title VII. Fast forward not quite 40 years, Peggy Young works as a driver at a UPS facility in Maryland. Her job requires her to lift packages up to 70 pounds in weight. She takes a leave in order to undergo in vitro fertilization to try to become pregnant. She succeeds and becomes pregnant. And when she tries to go back to work, her doctors tell her that she cannot lift packages more than 20 pounds without risking her pregnancy. So she asks UPS, which is covered by its own collective bargaining agreement, she asks UPS for an accommodation that's called a light duty assignment. She would continue to work, but she'd be in a job where she was doing a lighter job that didn't require her to put her pregnancy in jeopardy. Under the collective bargaining agreement, UPS said, no, you're not eligible for a light duty assignment, and since you can't perform your regular job requiring 70 pounds, you basically can't come back to work until your pregnancy is over. She eventually lost her salary and medical benefits under those circumstances. So what UPS says is our policy is that we're complying with the Pregnancy Discrimination Act. We treat everybody the same under particular work conditions. We're not discriminating against people on the basis of pregnancy. They say we will accommodate people with light duty work under 3 circumstances. One is if they've been injured on the job. 2 is if they've lost their Department of Transportation eligibility for a trucker's license. And 3 is if they're required or entitled to accommodations under the Americans with Disabilities Act, meaning they have a disability. Well, UPS says pregnancy is not a disability under the ADA. She hasn't lost her trucker's eligibility, and she's not injured on the job. So we're not discriminating against her. We're treating her the same as we would treat anybody else. She doesn't meet those qualifications. So they refuse to hire her. She loses benefits. She gets permission to sue from the Equal Employment Opportunity Commission. The case goes up on appeal to the Fourth Circuit, and the Fourth Circuit upholds UPS's policy that this is non-discriminatory. And so she's taken her case to the Supreme Court. The Justice Department, the Solicitor General, was asked by the court a year ago to weigh in on this issue before the court decided whether to hear the case or not. And it's a very interesting brief by the Solicitor General's office. It basically says virtually all of the federal appeals courts that have considered cases like this have gotten it wrong, including this one. But you, the Supreme Court, could probably wait for another set of facts or another set of circumstances before you decide this case. You don't really necessarily have to take this case. And furthermore, Congress was amending the Americans with Disabilities Act to make it clearer that pregnancy could be considered a disability in some circumstances, and the EEOC might adopt regulations that would make this case moot and resolve the problem. Well, Congress did amend the Americans with Disabilities Act law, but the regulations didn't seem to solve the problem, so the Supreme Court has agreed to hear the case. One additional note about it, there are always a couple of cases every term that make wonderfully strange bedfellows, and this is one of them. There are all kinds of coalitions of civil rights groups weighing in, saying that she should be entitled to be treated as if she were discriminated against on the basis of gender, that her treatment violated Title VII. There's also a coalition of pro-life, anti-abortion groups that have weighed in her favor on the premise that discriminating against people who are pregnant provides economic incentives for them to get abortions, and therefore that's not what Congress intended when it passed the Pregnancy Discrimination Act. It intended to facilitate childbirth and pregnancy, and so they've weighed in on her side as well, which makes it kind of a fascinating set of friend of the court briefs. My other case, that one's called Young versus United Parcel Service. My other case is called Holt versus Hobbs, also a civil rights case of sorts. Gregory Holt is a prison inmate in Arkansas who, as an inmate, is known as Abdul Malik Muhammad, and says that his Muslim beliefs require him to grow a beard of at least ½ inch in length. The Arkansas Department of Corrections says no thank you. They allow mustaches under their corrections rules, and they have a narrow exception for ½ inch beards for people who have dermatological problems. They have accommodated him in many other ways. He's allowed to have a prayer rug. He's allowed to have a copy of the Quran. He's allowed to have a special diet. He's allowed to observe Muslim holidays. But they say that a ½ inch or longer beard is a security risk. You can hide drugs in the beard. You can hide contraband, weapons, razors in the beard. And they make what seems like a fairly compelling security argument. The problem with their argument is that, according to the Justice Department and other briefs, more than 40 states have figured out how to accommodate this kind of request, as has the Federal Bureau of Prisons. So it's a little hard for Arkansas to maintain, we don't know how they do it, but we can't do it. It's too great a security risk here. They say that one of the extenuating factors is that the prison in question is a prison farm where the inmates are not in individual cells. They're in barracks-like settings, and that creates a greater security risk. And also they go off the grounds to work on the prison farm, meaning it might be easier for them to bring things back in to the prison. Again, one of the counter arguments raised in the briefs is they don't seem worried about the inmates smuggling things in their clothes. They just seem worried about their inability to keep him from smuggling things in his beard as a security risk. So it seems like a kind of strange argument to be able to maintain. But, and this is all brought under a federal statute, which I have to say the name of just for the sake of saying the name of it. Its acronym is RLUIPA. It's the Religious Land Use and Institutionalized Persons Act, passed in 2000. The Supreme Court has, on at least one occasion, said we need to defer to the expertise of prison officials when they say they are trying to maintain security. That could be a counterweight here in the way the court looks at this case. The legal standard, and I'll stop, is under this statute, the state has to have compelling reasons for adopting a policy that burdens somebody's religious freedom. The need to maintain prison security might be considered to be compelling reasons, but the second part of the test is that the state has to do it in the narrowest possible way, the least restrictive means. And the argument here is that the state can't possibly meet that burden, that this can't be the least restrictive means. So that case is going to be argued early in the term in October.
When it comes to predictability of what the court might do, how does this case compare to the Hobby Lobby, the last religious freedom case that the court decided on?
I mean, I think the Hobby Lobby raised a lot.
In terms of predictability.
I I mean, if I had, I don't like to make predictions, but if I had to predict, I would say it's going to be hard for Arkansas to overcome the fact that 40 plus
40
other states
have
and the
figured it
Bureau
out.
of Prisons and DC have all figured this out.
I would say one other thing about the prison context. Sometimes, we think of the justices as 9 cloistered people who are removed from daily life. Prisons is one where I actually think that they're getting it. They understand that prisons right now are operating with so much discretion and getting away with so much. Just if they can do something, they'll do it, whatever it is. If you haven't been to a prison, I encourage you to go and visit it and see what it's like. Because Justice Kennedy served on the California Prison Commission. He cares deeply about this set of issues. I think this one is, I feel comfortable arguing almost anything, but this one I would not want to argue on behalf of Arkansas.
But you would encourage people to visit the easy way, not the hard way, right?
Absolutely.
Want to be clear.
With an open door.
Janae, did you want to?
Well, what I think is interesting, if we think about a couple of the cases that we spoke about, so Gilbert and Holt, I mean, we're looking at the degree of discretion that the court is either going to afford to prison officials or to local officials about the signage that will go up in a town or the safety concerns. It'll be interesting to see if there's any inconsistency in how much deference is given to any state official depending on the context. And of course, prisons do present something of a thornier context, but I agree that the court's now on to the fact that our prison system is so highly dysfunctional. So we may actually see what I would think is the right decision here.
I mean, the inmate in this case is going to have the Solicitor General's office arguing on his side, the government that the agency that maintains the Bureau of Prisons. I mean, I think that's pretty powerful.
Any other thoughts on the cases Steve presented? Let me, before, we're going to soon come to your questions and comments. Comments on the brief side, please, and even questions on the brief side. You're going to have a couple of floor directors with microphones on either side who will help you get a microphone and ask your question. And that's one thing we would ask is please don't start speaking until you have a microphone firmly in hand and hold it up close to your mouth. And don't fiddle with turning it on or off. It will be on, trust us. Or not, or we'll scramble to turn it on for you. But before we come to that, a little more discussion here, I would offer the opportunity for any of you to bring up something that either popped into your mind during this segment that you didn't get a chance to say. This might be a chance to say it. Also, if there's another case you'd like to briefly highlight. But before, Janae, I just want to ask you back to the voting rights cases. If you look at the political landscape of voting rights, it seems like maybe we're into a period where we're going to be seeing a lot more cases make their way to the court. Could you comment on that? Is that your expectation as well?
I think that's right. I think we are going to see a voter ID case go to the court coming out of either Wisconsin or perhaps Texas, where we're litigating a case. We just finished closing arguments in challenging the voter ID laws, which are some of the most stringent in the country in Texas today. So we'll see. I think that that's probably the next frontier. Redistricting is always something that makes its way to the court. I don't know how much new ground there really is to tread there. Something that has changed, though, is because Section 5 is, for all purposes, defunct at the moment. We may start to see different challenges come to the court that are now unmoored from the Voting Rights Act, which could also be quite troublesome.
And I wanted to say a word about, Janae had mentioned a case called Shelby County from a couple of years ago. I think it's a very good case to be the counterweight to what I opened up my remarks with today about the court acting with unanimity. That was a bitterly divided 5-4 case that struck down a kind of landmark provision of the Voting Rights Act that had been around since 1965. And I'd argued the predecessor case 4 years before with Janae's colleague Debo Odegbile, which the Supreme Court had let that provision stand. But in 2013, they struck it down. And they struck it down on this notion that something they called the equal footing doctrine, that certain states are discriminated against more than others. It's basically made up. You can't find it in the Constitution, you can't find it in the precedent. And it's an interesting example of how, when I went to law school, it was the conservatives who preached judicial restraint and the idea that courts shouldn't do very much, they shouldn't strike down legislation is unconstitutional. And over the last 15 years, we've really seen a role reversal, and it's the conservatives that are flexing their muscles and using the courts to strike down a lot of legislation. And Shelby County is example A landmark statute passed 98-0 by the Senate and something like 421-3 in the House, reauthorized in 2006 by those numbers, and yet the Supreme Court struck it down.
Judicial activism is like gerrymandering. It depends who's doing it.
Exactly.
Right? Yeah. Steve.
Neil made a brief reference earlier, but I think we ought to just mention that there's a good likelihood that the Supreme Court will get some abortion cases, one or more this term. They have not agreed to hear any abortion cases yet. There are several variations of statutes that have been ruled on or are being ruled on in the federal appeals courts. I don't know whether I would say it's a certainty, but I think there's at least a good possibility that the court will have to decide one of these abortion cases, maybe this term, maybe next term.
Listen.
I wanted, in the spirit of looking ahead, since what we have is a partial Supreme Court docket, there'll be more things added before the term is up. So just a couple of things to flag. I do think that they will continue with their First Amendment fatal attraction. We might see some more cases being granted that are First Amendment related. One is Mahana versus United States, which will be looked at by the court in the September 29th conference. This is about a person who was convicted for providing material support to a terrorist organization, largely on the basis of ideological writings that he posted online, which gets to a different aspect of the same question about how much can mere words constitute a crime. This is a different type of crime from the threats crime. It's not clear that they'll take it, but it's a very unusual and very interesting case that brings up some classic First Amendment precedents. There's also been a lot of stuff happening in the lower courts involving commercial speech, or speech by commercial entities, I think would be the better way to put it, particularly rattling around in the DC Circuit. Claims by commercial entities that various types of disclosure requirements that they're subject to, such as country of origin labeling, that these violate the First Amendment. And the DC Circuit went en banc this summer to decide a case of this kind for the American Meat Institute. It's not clear what will happen in that specific case on the Supreme Court level, or if the Supreme Court will choose to look at any of this, but there's a lot happening in cases that resemble a little bit on the speech side, kind of what Hobby Lobby was like on the free exercise side. So it's possible that we could get a very, very important type of First Amendment case showing up within the next couple of years on the Supreme Court's docket.
We're going to come to your questions. If you want to get the microphones in play here, I'll give you a moment to do that. Go ahead. Raise your hand if you have a question. Give our floor director some help here so they can see who might have a question. Yes, sir, and someone on this side too. We'll get to you in a minute. Let me just quickly ask a question before we come to you about the court staying relevant. I remember think of the technology cases like the cell phone case, and now we have a Facebook case of a sort, even though technology is not the focus of the Alonis case. Generally speaking, how is the court doing in keeping up with changes that change the way we live and perhaps the way we decide cases?
So I had the Aereo case last year, which was about this company that allows you to kind of intercept over-the-air television signals and watch them on the internet and so on. And the justices did get a fair amount of criticism after the argument for people saying they didn't understand the technology and so on. I just find that, frankly wrong. I think the justices, spend a lot of time trying to get the technology right. I remember I clerked for Justice Breyer during the first internet case, the Communications Decency Act case in 1997. I was the only one at that point who had a laptop that connected to the internet in the court, and so they'd come to my office, and then they ultimately went to the library where there were 2 internet terminals to get tutored on the internet. But they worked their tails off to understand it, and it was a great opinion that they wrote. And I think that's true today. I think that they're spending a lot of time getting the technology right, and most importantly, I think the theme in technology cases is they've often gone slow and not done too much because they know what they don't know. And it's, in technology case after technology case, you see that. The big exception, of course, is that cell phone case where I think they just felt like, no way. If you get arrested, the government can search everything on your cell phone, every picture, every medical record, every contact, every bank account. No, that's not like the old searches incident to arrest when you have a crumpled up cigarette container and maybe you have a weapon in it or something like that. That the government said you could do, that the court said you could do, but this is a roving warrant to do whatever.
So they're keeping up to date.
They
Justice
also have
Scalia
their
is a
law
big
clerks.
gamer, little known fact. No, I just made that up.
Well, they have their law clerks to keep them up to date on the technology,
Well,
too. I
this
remember
group
in
of folks, these law clerks, I don't know, they're not too up on the technology.
And also, I mean,
in the California violent video games statute, I remember Justice Kagan, when she was expressing concern about the breadth of the ban in the statute, she made a comment about, my law clerks are back in the chambers playing some of these games right now. So they can get educated.
yeah, and Justice Sotomayor has mentioned that she's a fan of technology, and she, has more than one device that she uses. And I think just having that degree of diversity on the bench, and I mean technological experience diversity for once, is important for
One
the court.
hip and happening court, huh? They watch Disney HD, or whatever it's called. Yeah, I don't know. Okay, let's go to this gentleman right here with first question or comment. And what we'll ask all of you to do, sir, beginning with you, if you just would introduce yourself, tell us, if you have any affiliation, then ask your question.
Thank you.
Hi.
My name is Everett Bellamy. I'm an adjunct professor at Georgetown University Law Center. And I would like to ask Professor Kendrick, could you please tell us how Alonis got to the Supreme Court? What's the procedural history of that case?
So this is a case that arose in the Third Circuit. So Mr. Alonis, he was in the process of splitting up with his wife or moving out from the family home, and he made some threatening statements on Facebook about a coworker and got fired for that, and was continuing to make more threatening statements online. Most of this is through his Facebook account. So he eventually is charged. Mostly it's about the statements about his wife, although there are some other statements. There's one about how many kindergartens are nearby, and how many, now I'm getting into the statements, right? And with one weapon, how much damage you could do at a kindergarten. The only question is which one, these sorts of things.
The
And
FBI
so-
agent, too,
Yep,
right?
yeah.
Yes,
he went
and-
after the FBI agent on Facebook.
Yes, as people began to investigate him, he began to pile on a bit and find some new targets in the speech. So eventually he's arrested, and he's brought to trial. It's a Pennsylvania case, and the instruction that's given at trial is the standard that I was mentioning about, or the reasonable person. Would a reasonable person think that these were threatening statements? And that standard was upheld by the Third Circuit on appeal. And now what we have is in his seeking certiorari to the Supreme Court, it seems likely, of course the court doesn't disclose what its reasons are, but it seems likely that the fact that there is a pretty established disagreement in the circuits on what the standard is probably had a lot to do with their granting the case. They recently looked at and passed on another case raising the same issue. Perhaps they thought that case had some issues that would stop them from getting to the substantive question. But that's how we wound up where we are today.
My other bit of... Quickly,
Was he
please.
arrested and in jail, charged with a crime and fined, or
Yes,
what?
so there's a federal statute under which he was charged, which is a federal threat statute, and he was arrested and charged under that statute. And it's also not clear from that statute what state of mind you need, which is part of why this whole thing has become a First Amendment issue, because there's not a lot of clear direction from the statute about what's necessary. But yes, there's a federal threat statute under which he was charged.
As
Eventually
our
convicted.
first questioner graciously demonstrated, I also ask you if you could to stand when you ask your question, if you're able to stand. We're not going to ask you to lift 70 pounds, but it just gives the camera a better opportunity to find you. Did someone begin to say something and I stepped on? Okay, sorry. I'm hearing voices. Yeah, this gentleman with the microphone is next, yes. Or at least who motioned for it. Yes, sir.
Hi, Gabriel Hopkins. I'm a lawyer here in DC at Public Justice. I have a question. A lot of the topics that the panel has covered are kind of hot button issues, and I'm wondering if there are any sort of sleeper cases out there that may seem very dry on their surface, maybe procedure issues or, I don't know,
You'd like
financial
us some
issues.
boring cases you'd like us to cover?
That might have some larger impacts that people may not be
Sure.
anticipating. Yeah.
Of course. Thanks. Anything that comes to mind?
Well, I've got a bunch of those. I
was
think
afraid
the
of
one,
that.
I think the one that it probably will have the most significance for the nation's economy is a case called Learjet versus Aniak, which I'll argue in January, which is basically about whether states can regulate the energy markets or whether or not it's only federal law that controls. At stake are many billions of dollars. And the question in the case is, can states protect consumers with antitrust laws, or is the federal government laws preempt, sweep away all the state laws? The Article 4 of the Constitution has a supremacy clause in it, which makes the federal law supreme over states. And the federal government, Congress, has regulated the energy markets for a long period of time. The question now is, have they occupied the field, basically? Have they pushed away any state regulation, or can states regulate? And the energy companies say, if states can regulate, then we have to play by the lowest common denominator and operate to whatever the most restrictive state is. Whereas if it's a national rule, we have more certainty and predictability. Again, kind of dry, but something that's going to matter to everyone's energy bills each month.
There's another case, Jesenowski. I don't know that it necessarily will have broad import, but it's relevant if we think about the economic crisis and the number of homes that were lost through foreclosure. This case comes out of the 8th Circuit, and it asks whether a homeowner who has a mortgage, who wants to rescind that mortgage in writing within the statutory period, can do it simply by contacting the mortgage lender in writing, or must the homeowner also initiate a suit to officially rescind the mortgage. And obviously, the higher the bar, the more difficult it is for rescission, the more likely you're going to find folks finding themselves facing foreclosure. And so the economic impact of that case is something that we should probably pay some attention to.
I wanted to follow up on one thing that Neil said. Just generally speaking, when you ask the question, what are the boring cases that are going to turn out to, what's the sand and gravel that's going to turn out to be
Boring wasn't
really
your
important?
word, just to be fair.
Yes, no, I'm sorry, I'm putting words into your mouth. No. The sleeper cases, that's a better way to put it. And Neil immediately brings up a preemption case, and I just think preemption generally is it's an underappreciated part of the Supreme Court's docket. I think partly people don't put all the preemption cases together because they arise under so many different statutory schemes and so many different subject matter areas. But it's a hugely important question of who gets to decide questions, the states or federal government, and in everything from products liability to energy regulation. They're doing lots and lots of preemption cases, and it's important to keep an eye on them.
We have time for plenty more questions, but I have to do a little business here. Neil, it is 6:17, and I know that Neil has a pressing engagement he needs to leave for. So if you see him get up and leave in the next 2-3 minutes, it's not anything you said. And so, Neil, thank you. Let me thank you now, because we'll probably be into some discussion. Thank you for joining us. And as we continue, I just have a quick question. All of us up here have either currently teach or have taught. Steve has some students in the audience. Could you identify yourself if you're part of Steve Vermeil's class? There we go. Okay. And some students here from my Penn State class. Let's get a look at you as well. There we go. We are Penn State, all that stuff. Yeah, no, it's not a competition,
There's
Steve.
a former student here.
A former student. Okay, while we're on it, where's a former student? And the teacher evaluation forms will be available after the program. Who is next? The woman here has disappeared, strangely enough. I think she followed Neil Cacho. We'll go to you. Hi.
Hi, Megan Schuler. I'm an attorney at the Department of Justice in the Civil Rights Division. I'm interested on the Pregnancy Discrimination Act case. If you have a prediction for the outcome, given that the Solicitor General did say they think all the circuits got it wrong, and whether the Supreme Court will address at all whether the ADA Amendments Act does in fact protect pregnant women.
As I said, I hate to make predictions, but it's if I had to guess where the court is going to go with this, it looks to me like the court here and the other, this is the Fourth Circuit, but other courts that have wrestled with this are getting it wrong, that this is not consistent with what Congress intended when they passed the Pregnancy Discrimination Act, and at least to the extent that the 2008 amendments to the Americans with Disabilities Act should have at least boosted that argument, that doesn't seem to be helping either. So I would guess, if I were going to predict, that the court will rule against United Parcel Service and for Peggy Young.
Thanks. Who's next? Right over here on this side. Yes.
I'm Ariane DeVogue with ABC News.
Can I ask you to stand, stand, please, so we get a better look at you? Thank you. I want to check, we want to make sure who we're talking to here, you know. Can we get a bright light on you, please? No.
I just had a question. I happened to be looking at Facebook, and I think, and I have no idea, but I looked up and I saw that there was Alanis with the same name, and he's posting on Facebook. So I wanted you to talk sort of big picture. Either way the court rules, what is the impact on the average person who posts on Facebook? What's sort of the big picture impact of this case?
And you're talking about current posts. You saw posts recently.
I thought I did. I mean, I
Yes.
can't say for sure that but I
It's
just
the same
thought it was
person.
interesting, and I thought, what's the
Okay.
bigger picture?
Were they over the top?
Well, so, you know, I think the law professor in me resists the idea that what this case is about and what we should think it's about is the law of Facebook. You know, there's a kind of risk of creating what we like to call the law of the horse, right? The law of an inanimate object or a particular medium or something like that. And in the First Amendment area, by and large, the Supreme Court has resisted doing that. They want rules here that are all-purpose, that apply to people who are speaking face-to-face, who are publishing in a newspaper, who are publishing in Facebook, who are tweeting, whatever. Now, that doesn't mean that they aren't sensitive to the fact that our chosen media change, and that this is probably not a standard that's going to get played out through facts very much. It's going to get played out in Facebook and Twitter and other things. But they want something that's not medium sensitive, that applies across all media. And I think whether they're thinking about Facebook or they're just thinking about people speaking or whatever, partly they will be concerned about the question of, is our standard something that's going to chill people who engage in speech that's borderline but it's ultimately protected? By and large, historically in the First Amendment, they worry about the impact that their rules for unprotected speech will have on protected speech. The question is, what kind of rule would you need to have to make sure people feel comfortable posting on Facebook, to make sure people feel comfortable engaging face-to-face? And that's not something that and by the way, that's not the only thing they could be worried about here, but it's the type of thing that your question raises, and it's one thing that they could be concerned about. How exactly they'll decide to suss all that out, I don't know. But what they won't be trying to do is make the law of the Facebook.
I mean, I think, I don't know if you would agree, Leslie, I think if they opt for an intent requirement, either they say it's in the statute or they say the First Amendment requires it, then I think that gives you a lot more leeway in all realms of speech. You can say things that if the requisite intent is not there, you probably can continue to say. If I post on Facebook and say, you know, if you don't take that picture of me down, I'm coming after your family, if it's a reasonable person standard, I may be in more trouble for that post than if it's an intent requirement. I think it would be fairly clear that you can't tell that I really intended to make a threat in those circumstances, but a reasonable person might have felt threatened in those circumstances. That's sort of a simple version of the difference between the two standards.
Sorry. But I think a tough thing about it. So I do think that's exactly right, and people proceed on the understanding that a subjective intent requirement would be protective of more speech here. It would be harder to prove that someone had the requisite intent to say that their speech was unprotected. But intent itself is a tricky thing, and ultimately, in many cases, juries are going to be deciding it, or it's going to come down to evidentiary questions about what do we read, what gets let in by the judge, and contradicting a jury's assessment of what someone's intent is a kind of a hard thing to do. So it depends exactly if they say anything about how to implement that. If it's a question for judges, what types of evidence are relevant.
Well, and if Elonis gets a new trial,
Right.
which intent is required, I'm not sure he wins.
That's right. That's right.
That's what makes this case pretty interesting, because they can actually get both outcomes. They can use this as an example where the language is so strong that you can infer intent here, but yet it doesn't set too broad of a precedent to chill other speech.
Okay, thanks. Who's next? See, yes, ma'am. Hi.
Hi, my name is Brianna Bellotti, and I'm a politics, policy, and law scholar at American University. And just a general question. So what does the court's recent decision in American Express versus Italian Colors mean for the future of class action lawsuits? And do you see these type of lawsuits diminishing in number in the future due to this decision?
Are you one of Professor Wormeel's students?
No.
Oh,
I'm
okay.
a
I was just going to put you down for
undergraduate.
extra credit if you weren't. That's okay.
We'll find out who her professor is. And give it. I'm not a civil procedure expert.
Not either,
I
but-
mean, the court has been really hostile to class actions in recent years, and there has already been a significant reduction, I think, in the number of class actions in the courts. The requirement by the court that the commonality of interest of the parties in the class has to be much more rigorous than before. The sort of spate of rulings in the last few years, I think, has made class actions more difficult. Have you had some experience with it?
No, I would say that's absolutely right. This is just one in a long line of cases that make it very difficult to bring class action lawsuits. You know, you think about Walmart, which, you know, a few years ago, that also narrowed it. And, you know, preceding that, there has been a huge attack on the ability of lawyers to get attorney's fees in these sorts of cases. What I think we often ignore is how these procedural rules have an impact on vindicating rights. So we talk about the substantive cases quite a bit and the rights that are at stake, but they're only enabled by these procedural rules. And so they are as consequential in many ways as the substance, because you'll never get to the substance if you don't have the right procedural entree. So I'm glad that you raised that. That's a great question. I don't know of any cases on the docket this term that raise any of those issues, but or even that are pending, but who knows?
I think we have time for one more question, if someone has one. Yes, sir, right there in the middle. Thank you.
Hi, thanks. Phil Elia. I'm an attorney on Capitol Hill. I just had a question about the Alabama redistricting case and wondering if Section 2 of the VRA was at all in play there.
Yeah, that's a great question.
Did you explain for the uninformed what that is? Exactly?
Sure. So I talked about Section 5 already, and that is a part of the Voting Rights Act that's limited to specific jurisdictions. It was limited to specific jurisdictions until Shelby County versus Holder, where the court basically put that on hold. What is still in full effect is Section 2 of the Voting Rights Act, which again prohibits any voting practice, procedure, policy that has a discriminatory impact on minority communities, that lessen in any way the ability of those communities or those voters to elect a candidate of choice to exercise their voting power on equal footing. So Section 2 was raised in this case. It hasn't been the focal point. The defense was compliance with Section 5. Section 2 has been less developed. Of course, those of us who care very much about Section 2 are concerned that the court may decide to reach into Section 2 and talk about it, and there are lots of concerns about whether it may, there may be arguments about its constitutionality. I don't think this is the case that's really teeing that up squarely, so I don't think the court's going to reach that far to get to it, but that's always a concern, because that really is at this point the last piece of the Voting Rights Act that's currently in effect to really provide the broad protections against racial discrimination in the political process.
You know, earlier Neil had said that the same-sex marriage is the civil rights issue of our times. Hearing you talk about voting rights, the civil rights issues of past times are still unresolved.
Yeah, I might push back on that one with him.
No.
Both of them, there really is no hierarchy of civil rights issues. They're just sadly too many to deal with.
Before we close, I want to say a couple words of thanks. Thanks to our friends from the American Bar Association, Mabel McKitty Browning and Mark Cohen here in D.C. with us, and Kathy Hawk back in Chicago, who couldn't be here today. Also, if you want any more information from the Wilson Center, or the ABA Division for Public Education, please check our websites. That's where people who are joining us via webcast or via C-SPAN can get a copy of this really useful publication. I want to thank all of you. Thank the audience here in the room, the audience in the overflow room, the audience watching on C-SPAN 2, and also via the Wilson Center webcast. And then I want to ask all of you to join me with one final bit of business, which is thanking our outstanding panel, the three still with us, and Neil, who isn't in the room. Thank you. Thanks for coming. Thanks for watching. That's all for tonight.